Ready, start. Both the parties filed objections under Section 30 of the 1940 Act. Full stop. By a judgment dated 6th November 2004, the civil court substantially upheld the second award except for the direction to pay interest of rupees 10.63 lakhs on the ground that interest cannot be made payable on the amount of damages till it is quantified. Full stop. Being aggrieved by the judgment of the trial court, the respondent preferred an appeal in which the appellant filed cross objections. Full stop. By the impugned judgment dated 6th February 2012, the High Court allowed the appeal and dismissed the cross objections of the appellant. Full stop. The High Court set aside the second award to the extent of a claim of rupees 68.15 lakhs. Full stop. It was held that this claim was based on speculative and imaginary calculations. Full stop. As regards the claim of rupees 2.09 lakhs and rupees 18.64 lakhs, the High Court recorded that the respondent has accepted the liability. Full stop. On 13th April 2012, this court issued a notice. Full stop. The appellant was directed to deposit the amount involved with the High Court registry by way of interim relief. Full stop. Sri Vijay Hansaria, learned senior counsel appearing for the appellant, stated at the outset that the appeal is confined to the rejection of rupees 68.15 lakhs being damages for loss suffered due to non-performance of machinery and equipment. Full stop. The learned senior counsel submitted that even under the 1940 Act, the scope of interference by the civil court was limited. Full stop. He placed reliance on the decision of Madnani Construction Corporation within bracket P Limited versus Union of India and others. Full stop. The learned senior counsel invited our attention to clauses 15.2 and 15.3 of the contract. Full stop. These clauses were applicable when the plant supplied or commissioned and utilized by the purchaser yields below the minimum guarantee of 280 liters per metric ton. Full stop. The learned senior counsel has invited our attention to the findings recorded by the arbitral tribunal in the second award. Full stop. He submitted that the respondent never disputed the non-commissioning of the plant but stated that the machinery and equipment supplied are complete without any defect or fault as per the rated capacities mentioned in the parameters. Full stop. The learned senior counsel submitted that the claim of liquidated damages and breach of warranty were separate and independent claims and were rightly granted by the arbitral tribunal. Full stop. The learned senior counsel, therefore, submitted that the appellant's claim, to the extent of rupees 68.15 lakhs, deserved to be accepted. Full stop. Sri Chandar Uday Singh, learned senior counsel appearing for the respondent, has also made detailed submissions. Full stop. The learned senior counsel appearing for the respondent submitted that the finding on the issue of the entitlement of the appellant to the sum of rupees 68.15 lakhs has been correctly recorded by the High Court. Full stop. The learned senior counsel submitted that Section 74 of the Indian Contract Act, 1872 makes it clear that where a contract contains a clause stipulating liquidated damages, and the contract is broken, the party complaining of the breach is entitled to receive such sum not exceeding the mentioned amount. Full stop. The learned senior counsel also urged that in view of clause 21 of the agreement, the claim made by the appellant that they were unable to use the machinery cannot be accepted. Full stop. The learned senior counsel submitted that the High Court had already concluded the issue of the grant of the claim of rupees 107.54 lakhs in the earlier round. Full stop. He stated that no interference is called for in the view taken by the High Court. Full stop. The appellant's submission was that they could not use the supplied machinery and that the machinery was no better than scrap because the fermentation performance was lower than promised. Full stop.